Good afternoon where I am. Good evening, good morning, wherever you are. Hope everybody is doing well. Greetings, salutations. Yesterday I did one in the dark. I did a video in the dark. I don't know if is that a video, if it's in the dark and it's not intended to be in the dark. But anyway, that's what I did. So today I'm going to do, hopefully you guys can see me. Can you see me? If you can't see me, then tell me. And if you can see me, then you don't have to say anything. How's that? Just greetings, by the way, to StreamYard, Lee, Toe, the 1-1, Allen, Rondell, Hobbs, Mark, Renee, Gator Boy, Brian, Godzilla, Rodan, Scott, and everybody else. Thank you. Greetings. Hope everybody is well. And Kilvey. I hope that's correct. I kind of said I was predicting beforehand that the report would be out. The report came out on Saturday. And I have looked it over. It's 38 pages long. I thought I would summarize it. It'll be posted, I'm sure, as an 8K. I don't think it's posted yet. I think it'll be posted as an 8K. You all are welcome to study it and raise whatever points you find. I'm just trying to give you a basic summary of what's stated and then my interpretation, and you could reject or accept it or modify, however. Obviously not legal advice. Please subscribe, and share, comment, and do whatever else you want to do. First, I'm going to talk about, before I do the jokes, talk about my Dodgers. Started being a Dodger fan in 1966 when I was 7 years old. Had plenty of ups and plenty of downs. I am sympathetic a little bit to Toronto for unfortunately not having been able to close the door. I've been there, done that. No fun. And hopefully you will have success in the future, but so be it. That's baseball, and I enjoyed it very much. And hopefully the Dodgers will win again next year and piss everybody off again. So greetings. So thank you. That was my Dodger stuff. I did that with my father, who was an immigrant, when I was like 7 years old. So baseball, even though objectively it's boring, incredibly boring, that holds a special place in my heart. And I'm a very loyal person. So I was always a Dodger fan, always LA fan, sports teams. So that's that. What bird is known for choking? The blue jay. My sister lost her job at the bakery after making a customer violently choke. She said the owner told her to put her hair in a bun. My grandma pranks me periodically, pretending to choke. It's just an old gag. And last but not least, at least in the first section of these wonderfully amazing jokes, what veggie takes your breath away? What vegetable takes your breath away? An artichoke, unless it's a fruit. If anybody thinks an artichoke is a fruit, please let me know. Anybody out there think the artichoke is a fruit? No. So that's the vegetable. I'll come back to these at the very end just to kind of finish it out and get it done. So I went through the report. So the last dark live stream we did, I went through a bunch of deposition notices that were pending. I went through an objection that was done by the Rosie Memorial something, Rosie spelled R-O-S-Y, which struck me. I talked about Frank Benintendo and something he'd filed, and now we're moving forward. So after that, the report was filed, and it's the 5th interim report. And it says it's from the receiver, but I think it's from a combination of the receiver and the receiver's counsel. My impression is that the receiver's counsel generates it and the receiver has to sign off on it. I do not know if the receiver calls certain language for certain language in certain sections, or that's counsel. I do not know which way they do. It'd probably be up to the client. But that's kind of how it goes. So looking at the report again, I think it's 38 pages long. So this is the abbreviated version of that report. the receiver talks about he has four main obligations as a receiver: pursue and protect the assets of the receivership, and that's of GTII. And he says to a large degree, he thinks that's already been accomplished. So everything, I guess, according to the way they frame it, that all the major assets of GTII are frozen, are in a static place, or subject to some agreement, and that they've accomplished that. The second task and responsibility is to complete an audit, and to, I guess, file whatever other documents are needed with the SEC. And I think I read in the report, so there was originally a CPA firm was the auditor. They got shut down by everybody. Then there was a substitute CPA. Apparently they didn't cooperate, and apparently they overcharged too. And then there's the third one, which is the one that the receiver chose, that I think began in January of 2025. They're the ones that currently working on. Apparently, although we haven't seen it, and I don't know what the contents all are, but some preliminary financials were done in 2023, 2024 by the new firm. So that would have been in 2025. So they did some kind of projections submitted to the SEC. Now, what's interesting about that is in the course of the report, the receiver is clear stating that the financials, the bookkeeping, everything of the GTII by prior management was horrendous. And that's part of the issue that's taken so long in getting the audit done. So one other thing that the receiver talks about, amongst other things, is that he's not going to disclose when it's done, when the audit's done. And this is kind of like this, it's a little confusing to me. One part, they say that the stock's still trading, but retail is really not able to trade it or trade it vociferously or with aggression. And they don't want to give anybody a chance to get a benefit of that. Okay, but there are people trading, and I have asked you to stop it trading, and as opposed to giving me a rationale for it, and it could be in private, or it could be that I can't tell you because of this, or it could be I'll tell you why we can't do it. You've elected not to, and that's part of the problem here. And part of the report is the receiver, and this is where I think it's the receiver's language as opposed to counsel. The receiver seems to be saying, and maybe this is happening, everybody's threatening them and threatening to sue them, and they're trying to coerce them and whatever. He plays the victim here. All I've wanted him to be is transparent, to be quite honest. And when he doesn't report for 6 months, or he doesn't say why he can't stop trading, or he doesn't say why, or specifically who's trading it, and etc. That's why there's no transparency. That's why people question what he's doing. So I think the issue, and again, you could have two things true at the same time. So he could do a wonderful job, and he could be terrible at communicating and transparency. Can do both. Those both could be true. Now, I don't know if he's doing a terrific job. Other counsel has said they're satisfied, and I see he's working. But in terms of the communication and transparency, and maybe there's a justification, which he also hasn't disclosed, but that part, I think he sucks. So it could be both true, like in life, you could have positive, negative, both being true at the same time. So the fact that he's pissed off, that people are pissed off, that he's not disclosing things so that people have to speculate, sir, that's your own fault for not being transparent. That's my view, my own opinion. So he doesn't want to say when the audit will be done, and he uses justification. It seems like that he doesn't want to give an advantage to somebody who might be trading it, although at some point in time, the audit's going to be done. So this is the part I don't quite understand. At some point in time, the audit's going to be done. They're going to announce the audit's going to be done. The audit's going to be done before the stock's trading. So for everybody else, so if the audit's going to be done and he doesn't want to disclose that when the audit's going to be done because he's afraid of it trading, isn't that going to create even more of a pressure when they know at the last minute and they could trade and nobody else can? Doesn't really make a lot of sense. The reason not to disclose the date, approximate date for the audit. Again, unless the government's saying you can't do it, and then you could say that you don't have the right to this. You've been told that you can't do it. You don't have to describe why you can't do it, but they haven't said that either. So is what it is. Now, the only other part that I saw in there about the audit that I thought was interesting is it did suggest a couple things. And I'm reading from the report. This is page 6. By completing the audit and making, so this is what the receiver is saying. By completing the audit and making necessary SEC filings, I'm hopeful that the company's shares will trade again more freely. So I thought that was a positive statement. But he does say that ordinary shareholders have difficulty trading shares. So he must be suggesting there are certain, and I can't trade the shares, so I'm not trading, but there must be shareholders that they're suggesting are trading it in less than large volumes, even though they suggest it's low volume trading. So again, to the extent that the justification for not disclosing the date when the audit's completed or how much time it will take, I really don't understand it, honestly. But they do say that, well, I'm going to leave it at there. They do say, that they still expect it to be completed in the near future. I don't remember the exact language, but that was the interpretation. So they're basically saying they can't tell us when, but it's going to be soon. But what soon is, I don't know. Does that mean 2025? I'm thinking so, because then we'll be in another year and they'll have another year of financials. And I haven't seen any reference to a new year of financials. So I'm hoping it's this year, this last quarter, that we finally see the audit. And I was kind of expecting that. And if you recall, in the original order that appointed the receiver, that which was September of 2024, one of the things that's in there is about his ability to quickly file filings and to get the all the SEC accounting filings up to date. That's over a year ago. Not particularly quick. He does apologize for the delay. I think he does recognize that it's been overtly slow, but it is what it is. And again, I'm not blaming him for the slow. I might be blaming him for his optimism at first, and I'm blaming him for blaming shareholders. There may be ones who are not innocent, but most of the people I speak to are innocent shareholders who are just interested. So to the extent that the receiver is blaming the innocent shareholders for questioning his lack of transparency, I think you're not well taken on that point. And I think you better consider like a different strategy on that point. So I've mentioned two of his obligations as the receiver. This is referenced in his report. That's why I'm mentioning. So the first was the assets. Second was audit. Third is investigate claims against the officers, directors, and maybe family, friends of those. I think that's ongoing. And the fourth is chart a path for the receivership and possibly doing a transaction. And I saw this and I thought this was a little bit more, it concerned me a little bit. So it concerned me because and I'll get to it, but it concerned me because it suggests that the receiver might be pursuing other deals, not explaining what's going on or taking too long to explain what's going on. And I'll get to it because I'm going to read right from the report. So those were the four things that they're doing: assets, audit, investigate claims against officers and directors, a transaction of 4 points. And it's in that order. And right now they're on the audit side. And the receiver says that's why he's spending all his time is getting the audit completed. If he's spending all his time getting the audit completed, I don't know why it's taking so long, but so be it. We'll just take him at his word. Part of the report, the receiver bitches about his appointment and compensation. He says basically that he was appointed through plaintiff, and that, whatever compensation he's getting, it's hard work and, whatever, yada, yada, yada. That's in direct response to people questioning the amount of compensation based upon apparently him getting shares of shares that shouldn't have been issued in the first place, that weren't subject to any kind of court hearing or any response. And when he said it was plaintiff, it was not plaintiff, it was plaintiff's counsel. There was no consultation with plaintiffs. There was no vote. It was the plaintiff's counsel. And I'm not pointing fingers at plaintiff's counsel, but plaintiff's counsel didn't know about the 180 million or so disputed shares. All we knew about him is, I reiterate that, there was like 70 or 64 million shares that came up that had been issued. And then eventually Rabari or the board canceled half those shares, like 36 million, which left about 30 million. Those were the disputed shares. That's what people were thinking about was the compensation package. But apparently the receiver, who I know isn't interested in his own compensation, bitches and moans about this and kind of sets up the framework for, I guess, his request for more compensation. So he does indicate, again, the audit's taking longer than expected. The books were worse. Doesn't want to provide dates because he doesn't want to give advantages to shareholders. He talks about the mediation and settlement. And if you recall, there was a mediation. I think it started off with David Reichman. I think it was announced. There may have been others involved in mediation. They indicate that there's one negotiated settlement. There may be ongoing negotiations, but one negotiated settlement that they are going to be presenting to the court for approval that we will see. I don't know if that's with Reichman, David Reichman, or if that's with somebody like, Bronx Eye Care or somebody like that. We don't know because it's not disclosed, and I don't think they want to disclose it until it's presented in court. My guess is it'll be presented in court soon, but we don't know who that is. They talk about the Frank Benintendi deposition, which I intended. To kind of like give the broad points. They say that established there was a disengaged board. They talked about the Nuremberg defense, and that was the defense that Benintendi used. Basically, he was following the orders of Reichman, and that's why nobody was objecting. They raised questions about awards to insiders and friends without any sense of any connection to anything or GTII, which we've all talked about. And they talked about the questionable charities that have gotten shares for no particular reason, or no reason that has been stated. There's a whole bunch of additional depositions that are going to go forward. So let me talk about the proposed merger transaction and the section, because I mentioned it earlier, and now I'm going to talk about it, how it's referenced in the report on page 10 of the report. And it's talking about that it refers at page 10 to the third interim report, where it's talking about negotiations and at the AI-Versity. Then it says, so I'm just reading from the report now. Potential agreement with AI-Versity that was referenced in the receiver's third interim report was discussed with the court at prior hearings. I remain cognizant of many shareholders' desire to see this transaction close. I ask the shareholders to be aware of the realities of any transaction. I believe that both AI-Versity, the shareholders, and I are aligned in wanting any transaction to be successful. However, as parties to a transaction, both AI-Versity and GTII are pursuing their individual interests, which in both cases include maximizing the benefits to their individual shareholders. As is the case in any reverse merger, there would be ultimately some dilution, and the receiver is trying to do the best deal that he could do. He refers then to an August 2005 confidential term sheet from AI-Versity that contains terms that warrant further consideration. In that vein, they hired some company called Glass Ratner to evaluate the transaction and assist them. Additionally, there are certain conditions precedent to the closing that require his evaluation and resolution. When a decision has been made to the transaction, he will disclose it as accepted or rejected. So in my mind, that was a much less glowing endorsement, the AI-Versity deal, without any disclosure again. And he says they got the conditional, the new term sheet in August, September, October, November. We're now 3 months later. He had a law firm review it. Does it take 3 months to review a term sheet? I mean, literally, I've gotten term sheets before and responded the same day. So the fact that it's 3 months and you indicate that that a decision hasn't been made, and you haven't made a decision about conditions precedent, and you haven't indicated what those conditions are, that's kind of a mealy-mouthed response. It sounds like perhaps you're trying to evade that transaction. You even make reference to individual shareholders, but that's you too, right? Because according to you, at the end of this transaction, you might be the largest shareholder. So when you said that people are doing transactions for the benefit of perhaps suggesting the largest shareholders. Isn't that you? And aren't you implicating yourself in that? So why are we to believe, again, why do we believe you, period? Other than things that are verifiable. You kind of think that as to a security where everybody's got screwed and everybody knows it, and the receiver has specifically called out Reichman and his crew for committing all kinds of misconduct, where the receiver elects not to be transparent, and you expect those shareholders to trust you? Come on. Nonsense. So when you talk about now you're backing away, in my mind, maybe you're not backing away, but I don't know because I'm not involved in any of these discussions. I don't know where these discussions are. All I see is that you had some kind of term sheet in August, and I hear nothing else. Doesn't sound like you're actively doing anything as to that, or at least that's not said here. Maybe you are, just maybe you're not saying it. I don't know. But it causes me concern because I don't know what other transactions you might find, and maybe those will be. My concern all along is you're going to find a deal that's better for you personally, just like you claimed about the individual shareholders. Let me just read it again, just so he saw it. Page 10. Both AI-Versity and GTII are pursuing their individual interests, which in both cases, including maximizing the benefits to their individual shareholders, which is you. I think you're the largest shareholder, as is the case in any reverse of a sign. So I think you're the one who causes us the most concern about your decision-making as to this transaction, because you have the most at risk as any shareholder. And there's no reason we should trust that you will act in the best interest of the shareholders as opposed to your own individual. And the fact that you could apply to the court doesn't excuse that. I mean, you could have very talented lawyers who create very powerful arguments, and I'm not going to blame the judge for signing off anything. That doesn't cleanse a particularly uncleansed transaction. And again, if you hadn't started off your report by bitching about your lack of transparency, I wouldn't necessarily have given you this kind of send-off. But I think that you need to focus on yourself on page 10, because you're the one who has the most to benefit or to lose. And therefore, any decision you make with regard to that changes what you were going to do originally, because you were all in on the AI-Versity transaction. I don't know what those additional terms are. I have no idea. Just that you've changed your tone causes me concern, and I'm not particularly trustworthy of you. In other words, I don't trust what you say, and you show me, and I'll trust it. I'm not a particularly fan. You could be doing a great job, but I don't think you've done a very good job at communicating. So that's where we are. You talk about the claim process, and if you recall, there was a claim process. Everybody had a certain amount of time to submit documentation, and eventually, although there are some that are in negotiation, which they asked for an extension. I think one was David Reichman. There might have been a couple others where there was an extension. Oh, Bronx Eye Care. I think they asked for an extension. So without those, there's 9 claims. And I'm just going to read off the claims and the amounts. So these are the claims that have been made, monetary claims that have been made against GTII related to the claims process. Tommy Wang, Gecko PR LLC, Dorado Goose, AI Commerce Group LLC, they're claiming $42 million. The receiver says, there either be a resolution or they're going to litigate it. Raven Besso, like $1.2 million. Investigations continuing. Salvatore Loria, $180,000 based upon a note. I believe also, I'm not sure, but I believe he's the funder of the plaintiff's litigation. And I don't know if that creates a conflict that he has a claim and that he's the funder. And I don't know that for a fact. It was my impression that he funded the plaintiff's litigation. So if he funded the plaintiff's litigation, now he's seeking money. Is there a conflict? I don't know. I'll just throw it out there. Alan Schinderman, $17 million based upon some judgment. that apparently that claim is going to be rejected. John Scrodato, a CPA, apparently seeking 2 million shares as compensation, I think. Although the response is it doesn't look to be a claim in the proper format. So it's not Bronx Eye Care that the one who's, oh no, it says it's ongoing. Bronx Eye Care, 150 grand, settlement discussions ongoing. Michael Andreev, $1.8 million related to about 914,000 shares, which is the request, and it's being considered. It doesn't give us much detail. Now, by the way, any of these requests, the way I understand it, any of these requests that are adjudicated, there'll be court hearings, and so we'll have a better understanding of what these are connected to. Jeffrey Larkin, $84,000. He's seeking 60,000 shares. Doesn't seem to be a valid claim. Frank Benintendo, the gentleman that was deposed that I talked about, $859,000 for professional services. It's going to be rejected. I don't know what professional service. I don't know what services he provided. As indicated, the receiver thinks he's in on this and is responsible for it, and kind of let things happen without taking responsibility and without doing what he was saying. The total amount of the claims all combined is just under $64 million. I assume most of those will be rejected. Some might be litigated. And again, I got to find out if there's any connection between the plaintiffs and any of these parties to see how that impacts it. But those are the claims that are pending, and we will have hearings on those claims. Will they all be at the same time? I don't know, but we will see. On top of that, there's the process about the disputed shares. And the reason why I think that there's settlement negotiations still ongoing about the disputed shares with David Reichman is because on the list of the claims and on the list of these, there's 41 million shares that are nobody objected to. So of the, I think, 173 million or whatever shares, 41 million nobody objected to within the time frame. So what will happen most likely is that they will come back to the Treasury and be canceled. That's most likely. And the biggest ones in here, I'm not going to read them all. There's a bunch. Starts with American University, Anthony Matassa, who might have been the mechanic, by the way. Not the mechanic that you see in the movies, but the mechanic, literally. Donald Gilbert, who was an officer and director, 5,279,070 shares. I guess he didn't object because he knows that he's kind of in a bad position. Gabriella Falanga, I think it was a former girlfriend, 3 million shares. Icahn School of Medicine, 1.6 million shares, and then the 2.7 million shares. Michael Valet, 1.5 million shares. Any other big ones? Spencer Richardson, 1 million shares. The Anne Francis Trust, 2.2 million shares. And there's a whole bunch of other ones. But I don't see David Reichman's name here either. So since I don't see him on the claim and I don't see him here, even though it's not stated, my conclusion is that the negotiations with Reichman relate to the shares. And there's ongoing negotiations. And I think they believe that if Reichman rules and gives back his shares, that will put immense pressure on everybody else to return those shares. They don't say it precisely, but that's what I'm thinking. So, if somebody's holding 1 million shares and they came from Reichman and he returns them, it would be tough for somebody else to retain them. So that's the list of shares, the 41. So there'll be a hearing when those will probably be canceled. There'll be a hearing when there's a dispute as to the others. There will be a settlement hearing if there's a resolution with Reichman, Justine Reichman, anybody else has the shares. I think we'll know that within the next 90 days. That's my expectation. It's kind of indicated that if they don't get a resolution on those issues, then they'll go forward. They'll amend the complaint, go forward, including with a RICO charge against all these people. There's a bunch of lawyers involved too, by the way. They may have bigger issues to fry. So that's what they said they're also doing. They're waiting. If you recall, there was a lawsuit filed against the Astra or Astra. They're still chasing that down. They complained about numerous parties that have been they've been non-responsive and rude. And we've talked about some of them, and all these people are being deposed, I believe. Scott Oliphant, or Elephant, or Oliphant, Warren Markowitz, both lawyers, by the way, Hans and Rosie, ROSY, Epstein Memorial Committee, Todd Chisholm, Eric Mosteller, TSUI, MEI Wang, Rachel Wallet, Phil Fair, Paula Hill. I think all those parties are going to be deposed about their shares. And it'll be interesting to see again if any of these people take the fifth, because if I were their counsel, I would tell them to take the fifth. That's just my view. Knowing what the receiver says about these people, I take the fifth and the second. One thing that came up is the tax matter is again repeated, that apparently a lot of these gifts of stock, nobody paid any taxes. No 1099s were issued. So somebody owes a boatload of money. And if you recall during the Frank Benintendo deposition, or maybe you don't recall, during the Frank Benintendo deposition, he was asked about that, and he almost took a dump in his chair when he realized he might be responsible for all the tax liability of GTII, because that will be in the tens, I think, a big number, based upon the failure to do what was required. The other point that they focus on, page 32 of this report, is Justine Reichman is the largest shareholder of GTI, amongst the largest shareholders, other than the receiver, or potentially the receiver, or the future of the receiver. She holds like 7 million directly and 3 million indirectly, but she's done basically nothing. That's what it says. No consideration, no value, whatever. And she's not entitled to that. Now, why again? I'm just going to beat a dead horse one more time. Why the Receivers Council has waited this long to push Justine Reichman as opposed to suing her in California a year ago when I said it? I think it would have expedited things. I think it would have pushed everything faster. I think it would have pushed David Reichman faster. If it pushed David Reichman faster, I think it would have pushed all those disputed shareholders faster. So I think every time they talk about Justine Reichman, it just kind of reiterates that I think the strategy as to Justine Reichman was improper. We're entitled to disagree as a strategy. It's not like I'm making it up now. It's something I said from the beginning. So it is what it is. But they are suggesting that she shouldn't have all those shares. So just to kind of recap. So as a result, the audit's going to be completed soon, not specifically stated, hopefully by the end of this current quarter, so before the end of the year. There was some kind of draft financial that was submitted sometime in 2025. The assets of GTII are under control and management according to the receiver. The audit's something the receiver is actively working upon. They're also investigating the officers and directors, and they're also investigating or pursuing, or less pursuing, evaluating, doing a deal with AIversity, although in my opinion, it seems like a lot more cautious, removed. I gave an explanation as to why some shareholders may not feel entirely comfortable with the receiver and not be trustworthy of the receiver. Part of it because of where this stock has been and who has been involved, and part of it because of an election that the receiver has made to not be transparent. And he's given a reason, concern about the trading, because there's limited trading, and he's concerned about the trading, although I don't understand if the audit's done tomorrow, those same people that can trade will be able to trade and we won't be able to trade. So it doesn't make a lot of sense, but that's justification. So there is a justification. So that's the audit. The claims 9 claims were made of about $64 million. Most are going to be rejected. Some might be litigated. The disputed shares, 41 million apparently did not object, so those probably will be canceled. The other 130 million or so, Some of those may be negotiated. Some of those may be litigated now, separate from a trial. And there's ongoing negotiations with David Reichman and the receiver, in my opinion, based upon his absence from the lists. And I hope that finally the receiver goes after Justine Reichman, files an action. There's a tax issue, apparently, that the company didn't issue the proper tax notices, and the recipients of the shares apparently didn't pay taxes, which is a big problem for them, probably bigger than they ever thought. And my Dodgers won. That's a summary. I expect, and if any of you have, after you read the reports, if you have questions, feel free to put them out there, and I'll answer them to the extent I can. I will finish out with 3 jokes after I say, "Yay, Dodgers!" I just said it. What does a magician say while he's choking you? Chocus pocus. It's been 21 years since my dad choked to death on fresh sushi. This is not a true story, by the way. And my father has passed away, so I'm not going to jinx it. So it's been 21 years since my stepdad choked to death on fresh sushi. Fresh sushi. I think he got a raw deal. And last but not least, last night at dinner, I thought my father, who actually is not my stepfather, but my father, started to gag. It turned out it was just another dad choke. Anyway, hope you guys are well. Hope you guys had a great day. Be well. Take care of yourselves. Obviously, as I get new information, what I expect this week, probably some more deposition notices, maybe some more information from the receiver, maybe some more information from AI-versity based upon this report, maybe other stuff. But obviously, I'll stay on top of it, keep you apprised. Everybody have a great day. I hope your team wins too, like mine did. And be well. Have a great day. Have a great weekend. And see you tomorrow, maybe.